I had a nice little PowerPoint presentation to go with this first lecture on triaging your case, but the computer gremlins got it, so I apologize. Triaging your case, before I begin talking about it, I just want to make sure that everyone's clear, because I assume some of you don't do a lot of abuse and neglect cases, with two of the things I want to be talking about, because they become important and understand what I mean by triaging your case. The first is the merits hearing, and the second is the placement plan. The merits hearing is simply the trial that will be had, that Lily was talking about, to determine if your client abused or neglected his or her child. If there's a finding of no merits, child simply gets returned. The case is over. So the merits hearing is very important. If there is a finding of merits, there needs to be a placement plan hearing within 10 days of the merits hearing to determine what steps the parent needs to do to remedy the conditions that have now led to a finding of merits, which allows for an ongoing removal of the child. So in talking about this topic, you need to keep those ideas clear if you don't know, if you're not familiar with them already. Triage is basically a medical term. People come to an ER or a military hospital and they get categorized into one of three categories. The first category is the people that are just so injured that all they can get is palliative care to reduce their pain, but they're going to die pretty soon. We might call them goners. Another group is people who come in with injuries, but they're not urgent injuries. If they get treatment in a few hours or in a day, they'll be fine. And then finally, there are people who come in, and if you treat them really quickly, you can save a life or a limb or an organ. But if you delay too long, then they're going to have problems. And those are the people that, if you're a doctor you focus, or a nurse, you focus on immediately and intensely. It's not a perfect analogy to representing parents in abuse and neglect cases, but it's a relatively apt analogy. I don't use the terminology in my written materials, but I tend to think of parents as falling into one of three categories if I'm representing an abuse and neglect case. The goners, the repentant, and the innocent. The goners are the easiest category to sort of decide what they are and deal with. They are the parents. I define the goners as people who are more interested in their dysfunction than they are in their children. Okay? And you will get them. One thing I would caution you is not everybody who comes into your office looking like a goner is actually a goner. That sometimes people will rise to the occasion and surprise you, and they will get their act together, but you will know a goner through experience. They will be the person who fails to show up for appointments, and then when you call them, they'll just blithely act like your time is of no value to them, because it isn't most of the time. In fact, with every case I've had but one where a parent's been a goner, they've been court appointed. Generally, people who are willing to pay you for your work will not be goners, although I've had one goner client who was a paying client. But they will show up, they won't show up, or they'll show up without an appointment and expect you to drop everything to deal with them, or 6 months will go by and they'll have a problem with the treatment plan, but they will never tell you that, or they will move and won't give you a forwarding address, and the notice of the hearing comes back returned. They won't even have told you they moved. They are people that just are so enmeshed in their dysfunction that they don't really care about their kids. And I look at these folks, and I often think, used to think, man, were they raised by wolves? But then I realize that's really not saying nice things about wolves, because wolves do a pretty good job of taking care of their children. And I've never figured out. It's not like they were raised by the Manson family. I just can't figure out. But they clearly don't have the first idea of what it means to take care of something that you're responsible for that has free will, like a child. They just don't. They can't figure it out. So they are off doing whatever, and the hope is that the child will somehow raise itself, and I guess it gets passed on to the next generation. But a goner is a frustrating client. Now, if you're young or inexperienced or just doing this for the first time, there will be the temptation to play social worker. And I called you a social worker, didn't I? Or did I call you? Okay. There will be the temptation to play social worker. There will be the temptation to fix their dysfunction as opposed to getting them the services they need to fix their dysfunction. And I will tell you that that is exhausting. You're not trained to do it unless you're Lily and a social worker. And it's frustrating. And the attorneys I know, and I know a few attorneys, who just want to fix broken people. And they burn out real quick. So if you want to fix the broken person who comes to your office and is totally enmeshed in all their drug dysfunctions and responsibility dysfunctions and can't even figure out how to keep their own house clean, have at it. But I would just warn you away from exhaustion. The other thing I would warn you away is from a grievance, because it's very doubtful they're going to find the money to file a malpractice action against you once they permanently lose their child. But they will know how to write Columbia. So in representing a goner, what I want to do is simply keep myself from getting grieved when, in a moment of semi-clarity, they decide to blame me for what's happened. And the way you do that is simply warn them, and warn them repeatedly, of the risks that come from not fixing the dysfunction. And I have a standard letter that talks about the risks of not remedying the condition. Parental rights can be terminated under 20-7-1572, subsections 2 and 8, where the child's been out of the home for 6 months following the adoption of a placement plan and the parents not remedied the conditions, or if the child's been in foster care for 15 of 22 months. So I simply send them a letter warning them that if they don't complete the placement plan, they don't remedy the conditions, they don't get the child out of foster care, their parental rights can be terminated. And I might send them that letter a few times. But I certainly am going to have that letter in the file. So if I get the letter from Columbia saying that we'd like you to respond to this claim that you provided incompetent representation and caused this poor person to lose their parental rights, I can say they was warned. And if you want to play social worker, as I keep saying, have at it. But for a client who's more interested in their dysfunction than they are in their children, there's not a lot you can do for them. I think when you get to the point where you care more about the case than the client cares about the case, you've got a problem. The second category of parent are what I call the repentant. These are the parents that clearly acknowledge, I screwed up, but I want to get my kid back fast. Think about how you'd feel if you screwed up, your kid was now in foster care. You would be upset with yourself. You'd be scared about your child. You'd probably, frankly, reading what you read about foster care, you'd be terrified about your child. And so when I get a repentant client, what I want to do is figure out, how do I get a placement plan done that remedies that condition but gets the kid back quickly? And how do I get that kid into a place that's more comfortable for my client? Because in the hierarchy of things, foster care is going to be a lot less comfortable to your client than a relative that may be geographically distant, and even better is a relative who's local, who they trust, or a family friend. Okay, there's nothing preventing placement with family friends. If your kid has a best friend and those parents are willing to watch, that friend's parents are willing to take your kid, and you don't have family in the area, that best friend's parents can be an ideal placement, because that child is familiar, you're familiar, that child's familiar to those people, and your client will be familiar with the parents. It will just decrease the amount of anxiety your client has if you can get the child placed with either a local relative or a local friend. And the statute specifically encourages placement with relatives of the first and second degree. They are a priority for placement. DSS will often want to jump through a bunch of hoops before they place. But the fact of the matter is, all they need is a SLED check and a central registry check, and that can be done in hours. And once they've done that, I go in, if I know I'm not challenging the probable cause hearing, as soon as I get retained, I send DSS a list of potential first or second degree relative placement or family placement, friend placement, so that at the probable cause hearing, the child can be placed with somebody that's out of foster care. I mean, one of my first goals in any case is get the child out of foster care. There's a good number of reasons to do that other than just anxiety level. If you've got a child in foster care and during the pendency of the case, your client's visitation is going to have to be supervised. Most foster care workers do not want to deal with parents. And there's some pretty good reasons. These parents often have dysfunctions ranging from somewhat mild to really extreme. And they come over and meet with the foster care parent, and it's not often a pleasant interaction for the foster parent. And the foster parents don't know going in whether this parent whose child they have is going to be one of the pleasant ones or unpleasant ones. So they generally, after they've been in the system for years, just blanket won't supervise visitation. So that means the caseworker's got to supervise your client's visitation if the visitation is going to be supervised. And if the caseworker has to supervise your visitation, caseworkers may not be the most competent people in what they do, but they are definitely some of the most overworked people. So they are not going to have a lot of time to supervise your client's visitation. So if you can get the child placed with a relative or a friend, well, heck, your client can go hang out. They can spend plenty of time with their kid. It won't be ideal, but they can spend a lot of time with their child. And so if you've got a repentant, so to speak, client, get that child placed with a family member or friend who's local, and that reduces the anxiety a great deal right there because they can now spend a lot of time with their child. The second thing you need to do is get a treatment plan in effect. We'll talk about terms placement plan and treatment plan are used interchangeably. Placement plan is actually in the statute, but everybody calls it treatment plan. That's just the plan that gets come up with that is designed to show what conditions need to be remedied to return the child. And your client is supposed to be capable of complying with it. If you have a client who is poor, disabled, on limited income, doesn't own a car, one of the issues that needs to be dealt with is how are they going to get to the therapies they're supposed to go to if they're in therapies? Who's going to pay for the therapies that they're supposed to go to? If that's not part of the placement plan and your client has financial or transportation issues, you aren't doing your job. You're setting them up for failure. So figure out in setting up a placement plan, and Cherie Barton's going to be talking about the placement plans a little later, so I'm not going to go into great detail, but you need to think about what hurdles there are going to be to completion of that placement plan, because if you don't think them at the beginning, you're not going to get that placement plan completed. The other thing I would point out about placement plans is they can be modified. So if you've got a problem with the placement plan, file a motion for modification. I can't tell you the number of times that services that are part of the placement plan end up, after you do further investigation, end up being redundant or unavailable. And if you just sit and don't do anything about it, the SS will say you've never completed the placement plan and you'll never get the kids back. So file a motion to modify the placement plan if there's something in the placement plan that your client realistically can't do or doesn't really need to do to remedy the conditions. The whole purpose of the placement plan is not to make a bunch of steps that your client has to jump through to prove they're a good parent. It's supposed to remedy the conditions that led to the removal. So if the placement plan isn't remedying the conditions that lead to the removal, don't allow it to be part of the placement plan. If your client's issue is strictly dealing with a messy house, they don't need marriage counseling. They don't need drug counseling. They need somebody to come in there, maybe, and show them how to keep a cleaner house. But make sure that the placement plan is tailored to what led to the removal. Now, if you've got a client who is clearly what I call a repentant client, you want to think about getting the case done also without a merits finding. So generally, sometimes I've come in at the probable cause hearing with a proposed, that's less than 3 days after removal, with a proposed placement plan. And usually, if the damage is not major, the child hasn't been severely injured, if the parents haven't been really bad, DSS will agree to defer the merits finding upon completion of the placement plan. And then when the placement plan is successfully completed, the child gets returned, the case gets dismissed, and your clients don't end up on a central registry. So think about if you've got what I call a repentant client, a client who's done something wrong but just wants to get the child back, think about entering in a placement plan agreement and deferring the merits finding, because DSS will generally do it, and I've not yet seen a case where a parent has then successfully completed the placement plan and DSS has not agreed to forego a finding. I can give you, an example of a case that worked out really well where the clients came in very quickly acknowledging their fault. I represented parents once, came to me the day after their child was born. Child tested positive for marijuana at birth, and dad was also using. Mom and dad were living together. They were body-piercing artists that were heavily into tattoos and alternative culture, what our Court of Appeals call bohemians. And but they were really pretty nice people, but they smoked pot. And the statute says that if kid tests positive for illegal substances, DSS has to remove. So it was an automatic removal. The child's less than a day old, and the child's already been removed from their custody. But as a judge would later say in the case, it's only pot. And I understand it's illegal, but I've not yet seen the study that shows that a pot-smoking parent is any less able to take care of a kid than an alcohol-drinking parent. We have a lot of alcohol-drinking parents in South Carolina. So my goal was get these parents through some drug treatment for their marijuana, get them to stop smoking marijuana, and get this child back as soon as possible. Well, the nice thing about living in a bohemian subculture is they actually had a colleague of theirs who was willing to come live in their home. So by the probable cause hearing, we had a placement. The colleague lived in their home with the child. They all worked at the same place, so when they were at work, they just took the child with them to work. And within 72 hours of that child's birth, that child was living in the home. Within a month at the merits hearing, they were now testing negative for marijuana. They'd gone through drug treatment, and DSS returned legal and physical custody to them. Well, the court did. At the merits hearing, at the first review hearing, they'd been in ongoing, regular, weekly counseling. They continued to test negative for marijuana. DSS didn't want to dismiss the case yet, but the judge said, it's only pot, and dismissed the case. And I think it was less than 3 months from removal to dismissal in that case. Now, if I hadn't taken such a proactive approach, what can happen in cases like that? The kid's in foster care. You've got despondent parents. This is a newborn child. This is the time when the child's supposed to be bonding with somebody, and she isn't bonding with my clients. She's bonding with a foster worker. So let's say we then have a merits hearing and then a placement plan, and now it's 9 months down the road, and that child's well bonded with the foster parents and doesn't know my clients really very well at all. Now I'm going to have a giant custody battle on my hands, and my client may never get those children back. So when you get a removal case, you need to be proactive. You need to think about, what is it going to take to get that child returned? What is it going to take to maximize my client's contact with the child? What is it going to take to minimize the disruption in the parent-child bond? And you move forward from that. In the last category are what I call the innocents. These people didn't do it. They are innocent. And they will, of course, then not agree to a finding. So you are going to be preparing for a trial under ridiculously compressed time frames. I understand the logic behind you got to have your merits hearing within 35 days of removal, and we can extend it another 30. We might be able to extend it another 30 after that. But realistically, a lot of these cases, especially where it's, sexual abuse cases where it's strictly the child's word against the parent's word, and there's, 3 forensic experts that have interviewed the child, you're just going to need more time than that to prepare for that case. I mean, and whenever I get a sexual abuse case, my time frame is, first I'm going to do the paper discovery, and then when I get the paper discovery done, I'm going to have to depose their forensic experts to figure out whether the child's available to testify or not. And then once I figure out what parameters need to be placed on the child's testimony, I'm going to go to a motion for the child's deposition. And I'm way past my 95 days by then. And I hope I've got an indulgent judge. But I want to be prepared. But you definitely need to understand you've got a terribly compressed time frame, and there needs to be quick turnaround. There needs to be a thought process of what do I need to do to get ready for trial so I can get ready for trial quickly. And then try to just plow through and get ready for trial as quickly as you can. And there's going to be a lot more presentation today on what you need to do to get ready for trial, so I'm not going to go into that. But just understand, if your client's innocent, you're preparing for trial. And if you prevail at trial, it's great. It's like the case never happened. Your child gets returned to your client. If there's a finding at trial, then you're now sort of dealing with the same dealings you'd be dealing with a repentant parent. You've got to go now through the placement plan and get that placement plan in place and completed before you can get the child returned. The one last thought I would give to you on triaging your case is understand that you've got to provide your clients some guidance in thinking about which category they fit in. Obviously, you never tell a client they're in the goner category, but don't just assume because they come in with a list of dysfunctions that they're a goner. There are many parents who will rise to the occasion, and there are some parents who only have what you'd think would be some minor problems to fix to get their child back that just will never show the initiative to fix them, and you'll be left scratching your head. But there's a limit to what you can do for people who don't want to be helped. But the key thing, I think, is understand that there are certain cases that will almost certainly require a merits hearing no matter how awful the evidence is. And there are certain cases where you need to think long and hard about whether you want to push the merits issue or just get a treatment plan in place. I would specifically suggest that sexual abuse cases where there's not a lot of physical evidence are those cases where you're almost always going to have a merits case. And the reason you're almost always going to have a merits case is when you decide what to do, whether to push merits or not, think about if you have a finding, what sort of placement plan is going to have to be in effect then to remedy the conditions. Because if you think about that, you'll then come to realize maybe I got to try this case and can't agree to the merits. And the reason I say that, specifically in the context of sexual abuse cases, is part of the treatment for a sexual abuse case is your client's going to have to acknowledge to the child that he or she sexually abused that child. Now, folks who have sexually abused their child, who will admit it, have a real hard time doing that. Parents who say, I didn't do it, are left with this really bizarre, assuming for a second that they really didn't do it, are left in a really bizarre situation where they've got to acknowledge to a loved one who they are hopefully trying to protect that they did something heinous to that child that they really didn't do, or they end up with a situation where their parental rights are going to be terminated at worst, or they're going to have no contact with the child till that child turns 18 at best. So your client is going to be in that position if they are found guilty of if they're found to have sexually abused a child in a merits hearing. So understanding that, so no matter how bad the evidence looks against your client, if your client's saying, I didn't do it, prepare to win at trial by any means allowable. Because that's really all that's going to happen. In those cases, inevitably, if you lose the merits hearing, I've heard of 1 or 2 cases where the parents would later acknowledge the sexual abuse after merits hearing, but more likely what I've seen and heard is that the parent just loses any relationship with that child. So no matter how overwhelming the evidence in those type of cases, you just need to be preparing for battle. And for some reason, I seem to get these sexual abuse cases where I'm representing pillar of the community types. So that makes it even more difficult, because it's hard for the pillar of the community type to ever acknowledge they've done something like this. So if you know, just because the evidence looks really, really bad against your client doesn't necessarily mean you counsel, let's just go through a placement plan and get your child back. On the other hand, if the evidence is overwhelming against your client on, let's say, a drug case or a physical abuse case, you know, counseling your client to fight the merits is just bad judgment. Because what happens is, first of all, you now have the child in foster care or in another placement for a long period of time, during which time your client is losing that relationship with their child, and you're just delaying the placement plan implementation. Secondly, when you do get a placement plan, you know, if you come in, my client's sorry, they did wrong, they want a remedy, you know, DSS will and the courts will generally be helpful, cooperative, encouraging. But if you come in, they didn't do it, you prove it, you know, I'm going to make it, you know, I'm going to make it prove everything, and you just go through a gargantuan trial, and then you lose, well, no one's going to believe your client's sincerity when they say, now I want to remedy the conditions that led to the removal. So you do your clients a really big disservice, I think, trying some types of abuse and neglect cases where the evidence against them is overwhelming, because you're just making it harder for them to get their child back as opposed to easier. Remember, the goal should always be, how do I get the child back? And when you think about how do you get the child back in each particular case, that should guide you as to how to go about handling the case, whether to fight the merits or not fight the merits. Our next speaker is Diedrich von Lee. And of all the speakers we have on this CLA, I chose the topics, chose the speakers. I wanted one speaker who did not primarily do family law. And the reason was, I wanted somebody, many of you don't practice much family law. Y'all may think, I can't do abuse and neglect cases. So I wanted somebody who doesn't do much family law to tell you that you can. And I asked around my local judges, and it was said, who doesn't practice primarily in family court but does a bang-up job on handling their abuse and neglect appointments? And Mr. von Lee's name was suggested. So Mr. von Lee does primarily criminal with a little bit of personal injury, but he is to tell those of you who don't practice family law that you too can do it.
Thank you, Greg. By that introduction, I guess you can all figure out that I'm the token knucklehead today, who's going to talk to you about stuff that y'all probably do more than I do. But true story I want to start off with. A couple of months ago, I had driven over from Charleston to Berkeley County to make an appearance there in General Sessions Court. And as I was leaving the courthouse and walking down the sidewalk, for those of you who might have been to Monk's Corner, you'll know that the courthouse is co-located with the sheriff's office, and then further down the street from that is the Berkeley County Detention